The federal bureaucracy's policy influence is at odds with democratic principles. The bureaucratic form of governing is the antithesis of the democratic form. Bureaucracy entails hierarchy, command, permanence of office, appointment to office, and fixed rules, whereas the ideals of self-government involve equality, consent, rotation of office, election to office, and open decision-making. The President and members of Congress are accountable to the people through elections. Bureaucrats are not elected, and yet exercise a significant degree of independent power. Their influence raises the question of bureaucratic accountability, something we're going to talk about today. Bureaucratic accountability is the degree to which bureaucrats are held accountable for the power they exercise. Today we'll look at how the President, Congress, the courts, and the bureaucracy itself helps to keep the bureaucracy in check. There are three main ways in which the President can hold the bureaucracy accountable. The first one are the President's use of executive orders. Remember, executive orders have the rule of law. Executive orders can provide guidelines to executive and the federal agencies in order to pursue particular administrative actions in a way that the President seems fit. The most common way a President can hold the bureaucracy accountable is through his appointment power. For day-to-day oversight of the bureaucracy, presidents rely upon their political appointees. The top positions in every agency are held by presidential appointees. Their influence is greatest in agencies that have substantial discretionary authority. Remember, we talked about the difference between discretionary authority a couple of sections ago. Nevertheless, though, there are limits to what presidents can accomplish through their appointees. Because their appointees number in the hundreds, and many of them lack the detailed knowledge of the agencies they head, making them dependent upon those folks within the agency who have been there for a long time. In addition, by the time most of the appointees acquire reasonable understanding of the agency's programs, most of them leave. On average, a typical presidential appointee stays on the job for less than 2 years before moving on to other employment. So the first two are somewhat effective, but probably the best way in which the President can hold the bureaucracy accountable is through the Office of Management and Budget. In addition to overseeing the preparation of agency budgets, the OMB acts as a review board for agency regulations and policy proposals. No agency can issue a major regulation without the Office of Management and Budget's verification that the benefits of the regulation outweigh its costs, and no agency can propose legislation in Congress without the OMB's approval. In making these decisions, the OMB operates from a presidential perspective and probably provides the President with the best form of accountability. A common misperception is that the President, as the chief executive, has sole authority over executive agencies. In fact, Congress also claims ownership because it is the sole source of each agency's programs and funding. The most substantial control that Congress exerts over the bureaucracy is through its power of the purse. Congress has the constitutional authority over spending, decides how much money will be appropriated for agency programs, and without funding, a program simply does not exist, regardless of how important an agency may believe it is. Congress also has control through its oversight function, which involves monitoring the bureaucracy's work to ensure its compliance with legislative intent. If an agency steps out of line, Congress can call a hearing to ask tough questions and, if necessary, take legislative action to correct the problem. Bureaucrats are required by law to appear before Congress when asked to do so, and the mere possibility of being grilled by a congressional panel can lead administrators to stay in line. Finally, there are a couple of legislative steps Congress can take to control the bureaucracy. Congress has delegated much of its oversight responsibility to the Government Accounting Office, or the GAO. The GAO's role was limited largely to keeping track of agency spending, but has slowly expanded to now monitoring whether agencies are implementing policies in ways that Congress intended. When the GAO finds a problem with an agency's handling of a program, it notifies the appropriate congressional committees, which can take corrective corrective action. Finally, Congress has also devised a couple of ways to constrain the bureaucracy before it even starts to act. The simplest method is to draft more detailed laws. Legislation typically contains enabling provisions that give administrators specific duties to the administrators in how to implement a law. By including specific instructions in these provisions, Congress can limit bureaucrats' options and discretion. In addition, they can also provide what are called sunset provisions. These provisions establish specific dates when all or part of a law will expire unless it is extended by Congress. Sunset provisions are a method of countering the bureaucracy's reluctance to give up on outdated programs. Legally, the bureaucracy derives its authority from acts of Congress, and an injured party can bring suit against the agency on the grounds that it has failed to carry out the law properly. If the court agrees, the agency must change its policy. For the most part, though, the federal courts tend to support administrators if their actions are at least somewhat consistent with the law they are administering. The Supreme Court has held that agencies can apply any reasonable interpretation of statutes unless Congress has stipulated something to the contrary, and that agencies in some instances have discretion in deciding whether to enforce statutes. The recognition of the difficulty of ensuring adequate accountability of the bureaucracy through the presidency, Congress, and the courts has led to the development of mechanisms of accountability within the bureaucracy itself. Today I would like to talk about two of them. The first one are administrative law judges. Every day, bureaucrats make tens of thousands of decisions affecting individuals. Occasionally, an individual will believe that he or she was unfairly disadvantaged by a bureaucrat's decision and will contest it. Such disputes are handled by an administrative law judge. These judges are empowered to administer oaths, seek evidence, take testimony, make factual and legal determinations, and render decisions. However, they operate through a less formal process than regular federal judges. Administrative law hearings usually take place in an office or a meeting room rather than in a courtroom, and an administrative law judge does not wear a robe or sit on a high bench. The system is designed to provide a less formal, less expensive, and faster method of resolving administrative disputes than would be the case if they were handled through regular federal courts. Administrative law judges typically work within the confines of a particular agency and specialize in the laws and regulations governing its activities. The other one is something that we've heard quite a bit about in the last couple of weeks: whistleblowing. Although the bureaucratic corruption that is commonplace in some countries is rare in the United States, a certain amount of fraud and abuse is inevitable in any large bureaucracy. One way to stop these prohibited practices is whistleblowing, the act of reporting instances of official mismanagement, to encourage whistleblowers to come forward with their information. Congress enacted the Whistleblower Protection Act. It protects whistleblowers from retaliation by their superiors and gives them a financial reward in cases where their information results in a savings to the government. Nevertheless, and again, this is where current events come in, whistleblowing is not for the faint-hearted. Many federal employees are reluctant to report instances of mismanagement because they fear retaliation. Their superiors might claim that they are malcontents or liars and find ways to ruin their careers. As a result, whistleblowing does not often occur until an employee has moved to another agency or quits government service entirely. I'll have an article for you on the whistleblower case as we go forward. I want to thank you guys for your cooperation over the last couple of weeks. I know it's been a little bit different, but it does mean a lot to me, and I look forward to seeing you guys all on Monday. Have a great weekend, and on behalf of Clover and I, happy Fist Bump Friday.